This video is for February 27th. Welcome to YesToHellWith.com. This series is about legal fictions, and once you understand this legal mechanism, it will become clear why creating a statement of understanding is important. Let's examine why many people misunderstand the doctrine of legal fictions. Because if you misunderstand this, you will fight the wrong battle. And if you fight the wrong battle, you will lose, even while believing that you are right. So let's look at what a legal fiction is. A legal fiction is a tool of law that says, for the purposes of this proceeding, we will treat X as if it were true. Not because it is true in nature, not because it is true in God's law, not because it is scientifically true, but because it is administratively functional inside a legal forum. A legal fiction is not primarily a lie. It is a construct, a legal construct, a model used to make an institution operate. And this matters. A fiction is not an attack on your humanity. It is a classification tool within a system. Now let's look at why legal fictions were invented, the real reason. Historically, legal systems run into a problem. Life is too complicated to administer if every case requires full metaphysical proof. So law creates operational shortcuts. Legal fictions simplify adjudication, allow rules to be applied consistently, make institutions predictable, create categories that can be processed. Without fictions, modern administration collapses. Now here's the Liberty Dialogue's point. When a system begins to govern primarily by classification, it becomes a system of effect, not because law disappears, but because law becomes procedural machinery. Now let's look at a dated history from which legal fictions derive. Legal fictions are not new. They appear in early legal traditions, including Roman law, and they become especially developed in English common law. In older periods, courts had rigid forms, rigid writs, limited procedural access. So fictions helped courts reach outcomes deemed, quote-unquote, just within the constraints of the time. Over centuries, this became a normal part of legal reasoning. So when someone says, this is new, this is a scam, no, it's quite old and it's quite foundational. And that's why it's powerful, and that's why we need to understand it. Let's look at examples that people accept, but they don't realize in the legal fiction sense. Legal fictions that almost everyone accepts without thinking are corporations. They are treated as persons for rights and duties. An estate can own property, though it's not a living man or woman. Constructive notice treats you and I as knowing something that we've never read. Constructive possession treats us as possessing something that is not on our body. Agency binds us through another's acts. Imputation attributes knowledge or intent across roles. These are not spiritual statements. They are operational statements inside venues. The Liberty Dialogue's core distinction is this. There are two planes. Here is the single most important teaching point. These two planes operate at once. Plane A is natural reality. You are real. You are alive. You have natural rights. You are not paper. Plane B is a legal forum reality. In a court or administrative venue, the system must decide what category applies, what rule applies, who bears the burden, what remedy follows. So tomorrow we will finish this series and understand completely the issue of legal fictions. And as always, may truth reign supreme.